Hey guys, welcome back. Thanks for listening. We're going to talk a little bit today about some of the discrimination type cases that we handle here in the law firm. I get contacted by potential clients all the time, and when they're reaching out to me, they're generally in a position where something has happened in the workplace that has really traumatized their life. They can't pay their bills, they've been fired, and they believe it's unfair or illegal for why they've been fired. So most of these cases fall within the realm of what we would call traditional discrimination. That could be discrimination based on your race or discrimination based on your age, discrimination based on your gender or sexual orientation, or I'm not sure if I mentioned, or disability. There's a whole variety of potential topics. But you know what? When you've been illegally fired or you believe you've been illegally fired, it doesn't matter what type of discrimination. If it's unfair and illegal, that's why you're reaching out to our firm. And that's what we do. We analyze your cases. The truth is you're not calling us from a position of, hey, I'm just trying to find some stuff out. I haven't been fired or anything. When people reach out to us, they're in a dire position generally. They've lost their employment. They don't have the ability to pay their bills. They don't have the ability to buy their kids Christmas presents. And you wouldn't believe how many of these shady employers get rid of employees without reason right around the holidays. It's heartbreaking. It's an absolute heartbreaking situation. So we appreciate that you're here and looking for information about your claim. We hope that you're not in a dire situation, but if you are, obviously reach out to us. We're here to listen, here to try to help you and see what we can do, if anything, for you. Now, discrimination cases, people think about those smoking guns, like if you remember the movie Philadelphia, where you have these emails saying essentially, let's fire the guy because he's gay or he is a... The world doesn't really work like that. Employers have gotten a lot smarter over the years where the smoking guns, fire John because he's black and we don't like black employees. You don't really see those too much. We do get them from time to time where somebody's stupid enough to put something in a text message or an email. But, the common types of discrimination cases that we encounter or that we get retained for are what we call circumstantial evidence cases. Now, I'm not going to get all legalese on you, but here's essentially what it means. A circumstantial case is the majority of discrimination cases. And what that means is that you don't have that smoking gun firing John because he's black, for example, but you've got circumstances where John is treated differently than other white or Hispanic employees, assuming John is black, okay? Where, for example, you got a situation where 3 employees all do the same thing. 2 of them, the white and the Hispanic employee, aren't written up or disciplined, but John gets fired for it. And those are the types of what we call disparate impact or circumstantial evidence cases where you don't have that smoking gun situation saying fire him because he's black, but when you compare apples to apples, it's clear that John was treated differently for some reason. If you eliminate all of the other variables, it comes down to John was black and the other 2 individuals were white and Hispanic. And that alone is enough to trigger a claim for discrimination. And that's the type of case we handle. One of my favorite types of cases that I handle in the discrimination field is pregnancy discrimination. And it's something that hits home. I'm a dad. I've got a beautiful wife, 2 kids, and when women are pregnant and they're in the workforce, I really have a lot of respect and envy in that sense for them because it's such a difficult time in their lives. And from an employer perspective, you see the wheels working for what some of these employers want to do. They start the thought process of, she's going to be out for, 3 months. She's going to be missing all of this work time with medical or doctor's appointments. I don't want to deal with this. So what do? I had a client named Shelley who was a very successful employee, a branch manager at a bank, making close to $100,000 a year based on her tenure, and had excellent employment evaluations throughout her tenure. She'd been there a long time. Every year, above expectations, exceeds expectations, gets bonuses. In fact, in the 2 months before she disclosed that she was pregnant, she received another pay increase and another excellent evaluation. Well, guess what happens? You know the story. She gets pregnant, first child, very exciting time in her life for her and her husband. and she discloses it to her supervisor. And the supervisor's reaction was, "What'd you go and do that for?" Now, right there, come on. Forget about the work environment. That's just a dumb thing to say. But that sort of set the tone for what happened next. And what happened next is over the next 3 to 4 to 5 months, Shelley was written up and disciplined for things that weren't her fault, that were not her responsibility. Comments were made to her like, how much time do you think you're going to take? Like, are you really going to need all this time off? You know the business can't run without you. All these sorts of negative comments regarding her pregnancy. And if I had to show you the book without the last chapter, I'm sure you could tell me how it ended. They fired Shelley, and they claimed that it was based on poor performance. So to make the long and short of it, we certainly represented Shelley. We went after the bank aggressively, and they resulted or wound up resolving her case for a substantial sum of money. You can't treat people like this in today's day and age. And there's lawyers like us, the Florida overtime lawyers, who, that's sort of our trade name, if you will, who fight the fight for employees here in the state of Florida. If you're going to discriminate against employees, if you're not going to run a legitimate business operation that makes decisions based on legitimate factors, apples to apples, we're coming after you. We're very aggressive in that regard. A hot topic lately has also been discrimination cases against people of Middle Eastern descent. I represented an individual who, after some recent war activities, and the United States is always doing something overseas, but there was an invasion or a bombing of sorts. This is going back about 2 years, so candidly I don't remember exactly what the conflict was at that time. But the co-employees in the workplace started calling him Taliban, and they used the expression, and please excuse me, and called him a terrorist, and they would place like little fake bombs at his desk and run away. And he complained to management repeatedly, and management, taking the good old-fashioned America type of position, said, it's just jokes in the workplace. It's not a big deal, until it got serious. And one day at work, 2 employees threatened him with violence based on an event that had happened overseas, saying that he was part of it, these Muslims, as they refer to him. And he quit his job. He quit because he had complained and nothing was done about it. So, generally under the law, if you quit your job, okay, if you quit your job, you may be out of luck unless you've reported the issue to Human Resources and they fail to investigate. This is important, guys. You can't, if you feel you're being untreated unfairly in the workplace, you can't just pick up and quit. The law requires you to go to Human Resources or a manager. I always tell you to put it in writing, and say something to the effect of, I feel I'm being discriminated against. I'd like it to stop or at least have it investigated. Once you do that and management fails to investigate or remedy or stop the abuse, then you're well within your right to go ahead and quit. So anyway, going back to our client, he went ahead and resigned. We went ahead and filed a lawsuit on his behalf, and their position was he quit. We didn't fire him, and we made the argument that he quit because the conditions were so intolerable and they'd become dangerous. And we wound up with a substantial settlement for him because, you know what? There's one thing to be proud of your country, and we all are. I love this country, and I have a lot of pride, but it's another thing to affirmatively go out and treat somebody differently based on their national origin when they're American. Our client was an American citizen, but because he looked different, because he looked like, to use their words, one of them, they treated him in a disparate and discriminatory manner. And that's just the type of thing we're not going to tolerate. Briefly, age discrimination cases, we see them all the time. Here's the truth of the matter, folks. And as I'm getting older and older, I appreciate and respect it. Younger workers are generally faster than older workers. Younger workers are generally cheaper than older workers. But guess what? The law has protections in place. You have to, employers cannot go out and discriminate against employers over the age of 40, which is the threshold under federal law. In Florida, it doesn't matter what your age is. We've had cases where employers discriminate against somebody for being too young. And I was actually featured maybe 15 years ago in a USA Today article about, because I look young for my age, a judge said to me in court, will your father be arguing this motion for you? This is about 15 years ago. I have more gray hair now. But, younger employees in the state of Florida are also protected from discrimination. The bottom line is age should never be a factor. You see, as employees get older in the workplace, employers may start making comments such as, you planning on retiring soon? How much longer you think you want to work? These are all pinpointers or indicators of potential discrimination going on in the workplace. We see that if an employee does if an employer does what's called the reduction in force, we look at the numbers to see whether the majority of the people laid off are older versus younger. So these are all things where if you feel it in your gut, reach out to us. Let us take a look to see if we can either corroborate what you're feeling or tell you that it's just not there. Okay, but here's the point at the end of the day. You're reaching out to us. You're on our website for a reason. It's either, one, you just want information about your rights, just curious, or two, you're in a serious employment situation. And if you're in a serious employment situation where either you think you're about to be fired or you're being treated in a discriminatory fashion, reach out to us. Let us see if we can go ahead and take a look at your claims. Let us see if we can help you or at least give you some free guidance on our dime to say, here's what we would recommend you do. But it starts with you and complaining to human resources. Use your voice in the workplace. If you feel you've been discriminated against in the workplace or being treated unfairly, complain in writing to a manager or a human resources officer. I cannot stress that enough. So that's sort of my 2 cents, a little bit on what we talked about with regard to discrimination. Again, if you have questions for us, we're always here available for you. Reach out and we're happy to take a look. Hi, this is Richard Seller from www.floridaovertimelawyer.com. If you're a Florida employee and you feel your rights have been violated, reach out to our law firm, either toll-free at 866-344-9243 or at www.floridaovertimelawyer.com. I personally evaluate every claim that comes in, and I will give you the advice whether we think we can help you or not on your claims. Also, if you're outside the state of Florida, we handle cases all over the country. So go ahead and give us a call or an email and let us know how we can help, and you'll get candid advice from a candid lawyer about what to do with your claims.